with one big and obvious difference, which is that was the pre-Trump era time when people would have thought it was vaguely ridiculous to think that Donald Trump would be president of the United States. When I gave the talk then, it was simply an expression of admiration I had for these, I think, heroic civil rights lawyers. Now, however, I intend the talk to be an expression of hope and resilience in what I regard as a bleak and somewhat terrifying landscape that has become our national politics. I think, and I'm sure many of you think as well, though probably not everybody, that our nation's democracy is under threat from the most unprepared, reckless, temperamentally unsuited, boorish, and dangerous person ever to inhabit the White House. So I intend this talk as an expression of hope and resilience in that context. So now moving on to the talk. The simple act of becoming a lawyer for these people was actually quite complicated. The Southern system of Jim Crow did not allow African Americans to become very well educated, and literally not a single Southern law school admitted blacks until after 1950. Not that many American law schools admitted women either, and they were a rare commodity in the 1950s for those law schools that did. Harvard Law School, as you may know, did not admit women until 1950. When Ruth Bader Ginsburg matriculated in 1956, she was one of only 9 women in a class of over 500. At that time, women were not permitted to live in law school dormitories. Women were not permitted to dine at the faculty club, and the Law Review annual banquet invited members to bring their fathers, but not their mothers or their wives, to dinner. Early in the school year, the dean of the law school actually invited the 9 women who were then at Harvard Law School to dinner at his home. During the course of the evening, he asked them why they thought they should be taking up a place that presumably could be put to better use by a man. When Sandra Day O'Connor graduated from Stanford Law School in 1952, she was 3rd in her class, and the only law firm job she could get was as a legal secretary. Justice Ginsburg graduated from Columbia Law School in 1959. She transferred for her last year after her spouse, who had been a student at Harvard Law School, graduated the year before. She graduated tied for 1st in her class at Columbia, and she was a member of both the Columbia and the Harvard Law Reviews, and no federal judge in the country would hire her as a law clerk because they thought, as the mother of a small child, you couldn't rely on her to execute the responsibilities of the job. Moving on to special difficulties faced by these lawyers in their legal practices, it's useful to begin by thinking about how a typical lawyer prepares for a lawsuit. With most lawyers, most lawsuits, a client comes to you, you investigate the facts, you take a look at the law to see how it applies to your case, then you try to marshal the law and the facts in order to make legal arguments on behalf of your client. It was much more difficult than that for somebody like Thurgood Marshall or Ruth Bader Ginsburg. One obstacle that black civil rights lawyers faced in the South, which ordinary lawyers don't, was the threat and reality of physical violence. These lawyers were challenging, as you probably know, a deeply entrenched system of white supremacy that most whites were very resistant to giving up and were often prepared to use violence in order to preserve. Remember, it hadn't been very long before that blacks were being lynched in large numbers in the South in the 1890s. Annually, as many as 100 blacks were lynched by whites in the South, and as recently as the 1930s, that number was still more than 20 a year. Even as late as the 1940s and 1950s, many blacks who were engaged in civil rights protests were killed for what they were doing. Others were beaten and sometimes maimed. For example, when World War II veteran Etoy Fletcher tried to register to vote in rural Mississippi in 1946, according to a letter he sent to the NAACP, the registrar informed him, quote, "Niggers are not allowed to vote in Rankin County, and if you don't want to get into serious trouble, get out of this building." While waiting for a bus to take him out of town, Fletcher was accosted and then assaulted by 4 whites who drove him out into the woods, beat and flogged him mercilessly, and warned him if he ever again attempted to vote in Mississippi, he would be killed. In Montgomery County, Georgia in 1946, an African American named D.B. Carter organized an NAACP branch that was mostly devoted toward organizing African Americans to register to vote, mostly farmers and sharecroppers. As a result of his efforts, several hundred blacks did in fact register. After ignoring repeated warnings from the Ku Klux Klan to desist or else, Carter was severely beaten. Isaac Nixon, whom Carter had persuaded to vote, was murdered for registering to vote, and an all-white jury then acquitted the two whites who had killed him. Harry Moore, who was the founder of the Progressive Voters League in Florida, as well as the NAACP's lead lawyer in the case, was assassinated along with his wife when a bomb was planted under their home in Mims, Florida on Christmas night, 1951. Now, it wasn't just prospective black voters and NAACP officials who had to worry about physical violence, but also civil rights lawyers like Thurgood Marshall. Marshall was nearly lynched in 1946 when he was representing black defendants in what was known as the Columbia, Tennessee race riot of that year. Z. Alexander Luby and Arthur Shores, who were African-American lawyers, respectively in Nashville and Birmingham, they had their homes bombed in the early 1960s as a result of school desegregation lawsuits that they brought. There were other ways to intimidate civil rights lawyers in addition to the threat and reality of physical violence. A black lawyer named Arthur Madison was suing to compel registrars in Montgomery County, Alabama, to enroll black voters in 1944. He was then arrested, convicted, and summarily disbarred for representing clients without authorization. Apparently what happened is the county sheriff had intimidated Madison's clients into withdrawing their consent to his representation. No white lawyers were willing to defend Madison at the lawsuit prosecuting him. What happened to Madison was actually a serious problem for black civil rights lawyers generally. Their work required them to walk a relatively fine line around the ethical rules that constrain the behavior of lawyers, the violation of which can result in disbarment or criminal prosecution. Those ethical rules for lawyers were first developed in a very different context. For example, an individual was injured by a railroad. They wanted to bring a lawsuit. They came to the lawyer. The lawyer then filed suit against the railroad. Organizations established to litigate for social reform didn't and really couldn't operate in that fashion. The NAACP often had to encourage clients to bring lawsuits. It often had to financially support the litigation, and it often had to exert far greater control over the litigation than was customary in ordinary lawsuits. For example, NAACP officials would go to a meeting of black teachers and they would try to educate these people about their rights, for example, telling them they had the right to be paid the same as white teachers doing similar work. Then they would encourage them, or at least tell them that they could sue to vindicate their rights. They would solicit a plaintiff, ask somebody to volunteer, and then, of course, they would have to create an insurance fund for that individual because as soon as a teacher you brought a lawsuit against the school district, you were certain to be fired. NAACP lawyers who participated in events like that were violating the traditional ethical constraints against fomenting litigation. Clients are supposed to bring lawsuits to lawyers rather than the other way around, and also constraints about financially supporting litigation. Again, it's supposed to be clients rather than lawyers who support the litigation financially. Enforcement of these sorts of ethical constraints on lawyers was actually a very important mechanism that southern states used to try to shut down the NAACP in the late 1950s in response to the school desegregation litigation that culminated in Brown. Another problem faced by these African-American civil rights lawyers in the middle of the 20th century was the racial prejudice they faced from judges and juries, all of whom were white in the 1930s, 1940s. When black NAACP lawyers argued their cases before the Fifth Circuit in the early 1930s in lawsuits challenging the exclusion of African Americans from the only primaries that mattered. It was a one-party South. The Democratic Party was the only party, and the Democratic Party would exclude blacks from participation. In litigation challenging that, the judges on the bench literally turned their backs on the black lawyers, not wishing to acknowledge or legitimize their presence in the courtroom. In correspondence with the National Office of the NAACP, these lawyers repeatedly doubted if it was even worthwhile to show up for oral argument, whether Southern judges would ever vindicate the rights of African Americans, and whether their only hope was appealing their cases to the Supreme Court. Yet the Supreme Court also was hardly an hospitable forum for black lawyers. Justice James McReynolds, those of you who have been in my classes will recognize McReynolds as the worst human being ever to sit on the United States Supreme Court. McReynolds also literally turned his back on Charles Hamilton Houston when he argued the Gaines case in 1938, challenging the exclusion of blacks from higher education in Missouri. Now, Charles Hamilton Houston was a Harvard Law School graduate, like all of you soon, hopefully. He was a protege of Felix Frankfurter. He was the dean of Howard Law School, and yet Justice James McReynolds swiveled around in his chair to confront his back to Charles Hamilton Houston in order to express his disdain at the idea of a black lawyer arguing in front of him in the Supreme Court. Women's rights lawyers faced analogous but not identical challenges in arguing sex discrimination cases before elderly male justices who did not always take their claims with the seriousness they deserved. In 1946, the justices confronted the question whether federal statutes permitted the federal courts to exclude women from juries in states that actually permitted women to serve. So you're in a state where women are technically eligible, and the question is whether they ought to be sitting in the federal courts in those states. Internal records make clear that some of the justices considered the exclusion of women from juries to be a laughing matter. Justice Douglas, who wrote the opinion, which actually invalidated a criminal conviction on the ground that excluding women made the jury unrepresentative, Justice Douglas sent a jocular note to Justice Frankfurter proposing this division to Frankfurter's proposed dissent. Quote, Mr. Justice Frankfurter would eliminate all sex from juries by including only males. Not to be outdone, Frankfurter replied with a proposed addition to Douglas's opinion, quote, Mr. Justice Frankfurter, being a Victorian conservative, does not believe defendants are entitled to a sexy jury. Now, Frankfurter and Douglas, whom you may know, could barely stand to be in the same room with each other. They hated each other. They were able to find common cause in their sophomoric humor regarding the question of whether women actually ought to be able to serve on juries. 30 years later, oral advocate Ruth Bader Ginsburg faced similarly condescending humor from the bench as she challenged the exclusion of women from juries in the state of Missouri. Ginsburg concluded the oral argument she was making in the case. One of the justices leaned over from the bench to ask her one final question, so you won't settle for putting Susan B. Anthony on the silver dollar. In a 1970 case from New York, a state judge told a civil plaintiff who was challenging, again, the exclusion of women from juries, not to complain to the court because her sisters prefer, quote, television soap operas, bridge and canasta, the beauty parlor, and shopping over jury service. Moving on, I want to emphasize another point about the jobs of these pioneering civil rights and women's rights lawyers, one that I think really doesn't get sufficiently appreciated today, though if you were in my constitutional history class, you may recall we talked a little bit about this. We think of lawyers primarily as people to go into court in pursuance of a legal claim, but in some ways the most important job that these lawyers were doing did not take place within the courtroom. It took place outside of it. Civil rights lawyers went into southern black communities and they tried to educate people, many of whom were still illiterate and few of whom knew much about the Constitution, to educate them about the rights that they held, rights that white people were bound by law to respect. Black civil rights lawyers such as Thurgood Marshall and Charles Hamilton Houston saw part of their role, an important part of their role, as mobilizing Southern blacks to fight against an oppressive status quo, encouraging them to believe that progressive racial change was in fact possible, boosting their morale by demonstrating to them that there were in fact outside organizations that were willing to fight on behalf of their interests, and an outside organization that was committed to helping them overcome what at the time must have seemed like almost insurmountable barriers to progressive racial change. Houston, who was the NAACP's chief litigator in the 1930s, saw a principal goal of the litigation campaign as, quote, arousing and strengthening the will of local communities to demand and fight for their rights. Thurgood Marshall's biographer, my colleague Mark Tushnet, writes of Marshall being brought to town ostensibly, quote, to work on litigation, but actually to rally the troops. In a letter he wrote to Thurgood Marshall, Houston referred to himself as, quote, not only lawyer, but as evangelist and stump speaker. The NAACP recognized the important beneficial psychological effect that simply putting a black lawyer in front of an audience consisting of whites and blacks in Southern courtrooms could accomplish. Southern blacks were not accustomed to seeing black people stand on a footing of equality or near equality with whites. But a black lawyer in court could, for example, cross-examine a Southern sheriff who was denying that he had beaten a black defendant into confessing. Such performances had enormous and beneficial effects on black audiences in the courtroom. Here's how Thurgood Marshall described what happened in a courtroom in the small town of Hugo, Oklahoma in early 1941 as he defended a black man named Lyons against murder charges that were quite possibly trumped up. This is a letter that Marshall wrote back to the Home Office in New York. Lyons had been beaten into confessing, which was a fact that Thurgood Marshall was trying to get the sheriff and his deputies to admit under cross-examination. Marshall and his co-counsel, a white ACLU lawyer named Stanley Belden, had agreed that Marshall would cross-examine the law enforcement officers because, quote, we figured they would resent being questioned by a Negro and would get angry, and that would help us. It worked perfect. They all became angry at the idea of a Negro pushing them into tight corners and making their lies so obvious. Boy, did I like that. And did the Negroes in the courtroom like it? You can't imagine what it means to these people down there who've been pushed around for years to know that there's an organization that will help them. They are really ready to do their part now. They are ready for anything. Okay, so I think it's important to emphasize that for black civil rights lawyers in the South, this was at least as important a part of their role as the actual litigation and trying to come up with winning legal arguments in court. They educated African Americans about their rights. They mobilized Southern black communities to challenge the racist status quo. They gave blacks the hope that in a system of extreme racial oppression, it might actually be susceptible to change, and they provided concrete role models of African Americans standing up to white people and demanding their rights. Ruth Bader Ginsburg, to turn to the other half of my story, Ruth Bader Ginsburg argued 6 landmark sex discrimination cases in the Supreme Court in the 1970s. She won 5 of them. That's not a bad batting average, to use one of my favorite metaphors, though not necessarily hers. She's a much bigger fan of opera than she is of baseball. I think most people today, though, know less about what Ginsburg did outside the courtroom in terms of trying to help mobilize a movement for social change. The strategy of the Women's Rights Project, which she helped to found in 1970 and which was explicitly modeled on the NAACP, included not just litigating cases, but also lobbying legislatures, training lawyers, and trying to educate the general public about issues of sex equality. Ginsburg and the WRP, the Women's Rights Project, offered assistance to ACLU affiliates across the country who were engaged in sex discrimination litigation. She advised them on priorities, and the WRP served as a clearinghouse, both for information involving pending cases and providing a list of lawyers around the country who were willing to support such litigation. After her victories in the Supreme Court, Ginsburg would sit down right away and write memos to ACLU affiliates, instructing them on how they might think about pursuing follow-up litigation or legislative lobbying. Ginsburg devoted at least as much of her time to educating the public about sex discrimination as she did to actually litigating sex equality cases. Her female students at Rutgers Law School in the late 1960s asked her to teach a seminar on women in the law, and she sat down and spent a month in the law library reading all the cases and all the the law review articles relevant to sex discrimination she could find in order to prepare such a course. Now, she reported that that was not a very taxing undertaking, given the relative dearth of cases and commentary on the issue. Ginsburg and two of her colleagues then put together one of the nation's first case books on women and the law, and she encouraged other schools to offer such classes. She herself wrote numerous law review articles about sex discrimination litigation, and she maintained a steady stream of correspondence with law students around the country, encouraging them to write about recent sex discrimination cases, trying to educate them about the issues that were involved, providing them with copies of the briefs she had written and other materials that might enhance their scholarship, and supplying words of encouragement. At the same time, she also traveled around the country, lobbying state legislatures in support of the Equal Rights Amendment, speaking to affiliates of the ACLU, university audiences, as well as other gatherings, trying to educate people about sex equality. And so again, I emphasize social reform litigation, it's important to note, is not just about winning cases in court. It's also about trying to educate public opinion in support of social change. All right, social reform leaders not only organize and mobilize protests, but they also provide valuable role models, as I was just suggesting a few minutes earlier with regard to Thurgood Marshall, whose appearance in Southern courtrooms had beneficial effects on the black communities that witnessed his performances. Same thing was true about Ruth Bader Ginsburg. In 1960, of course, there had never been a woman on the United States Supreme Court. There wouldn't be for another 21 years. And there had only been about 2 or 3 female federal judges in the entire history of the Republic. In the late 1940s, President Harry Truman apparently considered the idea of putting a woman on the United States Supreme Court. That would have been a judge named Florence Allen, who was on the Sixth Circuit, and at that time, 1946, was literally the only female federal judge in the country. When Truman consulted the sitting justices, which apparently was a mistake, he consulted them about the idea of having a woman join them as a colleague. They objected, apparently because they were concerned that her presence would prevent them from taking off their ties and kicking up their feet during conference discussion. In the mid-1960s, women were only about 1% of Supreme Court litigators. They were less than 2% of the nation's law professors. Justice Ginsburg, in her 3 years of legal education at 2 different law schools, did not have a single female law professor. Not until 1970, if you can believe that, the American Association of Law Schools actually changed its rules to bar sex discrimination by member institutions. As of that year, 1970, women still comprised well under 10% of law school student bodies. Ginsburg herself appreciated the importance of female lawyers participating in these sex equality cases she was bringing in the 1970s, just as the NAACP in the 1930s had appreciated the importance of civil rights lawyers being African American, at least some of the time. When Ginsburg learned of the ACLU's involvement in the case of Reed versus Reed, which turned out to be the path-breaking 1971 first ever Supreme Court decision striking down sex discrimination, she asked Melvin Wolfe, who was the director of the ACLU, whether a woman ought not to be involved as co-counsel, and he promptly invited her to join the case. In WRP litigation, as Ginsburg later observed, quote, particular attention was given to encouraging participation by women lawyers who seek assistance in maintaining their skills during periods when family responsibilities prevent them from working full-time. Ginsburg's leadership of the WRP and her oral advocacy in those Supreme Court cases were inspirational to countless women, and she received many notes of gratitude and expressions of gratitude for her inspirational role. She herself never failed to acknowledge the landmark path-breaking achievements of earlier feminists. For example, in her landmark brief in Reed versus Reed, she placed the names of feminists Dorothy Kenyon and Pauli Murray on the title page as a kind of symbolic acknowledgement of the pioneering roles they had played. All right, moving on to a slightly different point, getting closer to the end. One might think that the main difficulty lawyers face coming up with convincing legal arguments, that the main difficulty they face is coming up with convincing legal arguments, but for black civil rights lawyers and pioneering feminist lawyers, that often wasn't enough. The system they were challenging was so fundamentally unfair that even arguments that seem obviously compelling often would lose. One of the most important cases that Oliver Hill, who was the path-breaking black civil rights lawyer in the state of Virginia, one of his most important cases was that of the Martinsville Seven, which arose around 1950. Many civil rights and constitutional law experts today are not familiar with the case. It was a really big deal in 1949 when the facts unfolded. 7 young black men were charged with raping a white woman in Martinsville, Virginia in 1949. They were prosecuted, convicted, and all 7 got the death penalty. Hill helped represent them for the NAACP. Now, their trials were actually reasonably fair given the place and time. Unlike with regard to many similar trials that were taking place in the Deep South around this time, the Martinsville Seven actually had capable lawyers who were appointed months before the trial began. They had a reasonably fair trial judge who tried to avoid prejudice in the courtroom. They had a trial that was not dominated by mob spirit or the threat of lynching, and they had not been beaten into confessing. As I said, that was quite different from the way similar sorts of trials in states like Alabama or Mississippi might have been conducted around the same time. For example, Charles Trudell was a 15-year-old black youngster who was charged with murdering a white man in Wilkinson County, Mississippi in 1946. He had to be transferred to another county's jail because of threatened mob violence. Defense counsel in Trudell's case was, according to correspondence that's been preserved in the NAACP files, defense counsel was, quote, skating on thin ice in the trial of this case in the courtroom packed with a vengeful community which overflowed even into the courtyard. Trudell's lawyers tried to make the record as good as they could, quote, without having their clients lynched on the spot, yet even a motion for special jury veneer would have resulted in immediate violence. The trial of the Martinsville Seven was meaningfully different, and also, it turns out that there was not much question about factual innocence. They were, in fact, almost certainly guilty of the crime of rape. There are only 2 problems with their trials and their death sentences. All 72 jurors who sat in the 6 cases of the 7 defendants were white, and the state of Virginia never executed whites for the crime of rape, only black men who had raped white women. Of the 45 men executed by the state of Virginia between 1908 and 1950 for the crime of rape, every single one was black. Now, the only way they could get away with that was ensuring that blacks never sat on these criminal juries. Hill and the NAACP raised that legal claim in the Supreme Court. The claim is not that the trial was unfair, but rather that racially disparate administration of the death penalty, which is possible because of the systematic exclusion of blacks from juries, violates the Equal Protection Clause. Now, it seems pretty hard to deny the justice of that claim. If the state of Virginia is not executing whites for the crime of rape, then it shouldn't be executing blacks for that crime either. That claim, not surprisingly, won in the Supreme Court, but not until 1977. It did not win in 1951, when Oliver Hill was urging it to the Supreme Court. Indeed, the Supreme Court didn't even think the issue was worthy of review in 1951. So the Martinsville Seven were executed by the state of Virginia, making this the largest mass execution or lynching for the crime of rape in American history. Ruth Bader Ginsburg confronted an analogous difficulty when she was trying to convince elderly male justices of the validity of sex discrimination claims in the 1970s. Now, the problem from her perspective is that virtually all sex classifications were, as she likes to say, a double-edged sword. Many such statutes tangibly disadvantage men, not women, though they intangibly harm women because they perpetuate stereotypes of female dependency, female passivity, lack of business acumen. Ginsburg needed to convince the justices that women were actually harmed by laws that, for example, permitted young girls access to a certain sort of alcohol at a younger age than boys, that required men but not women to pay alimony, or permitted women but not men to choose whether they would serve on juries. In a telling conversation with Harvard Law School students in 1973, Justice Potter Stewart had expressed bewilderment at the notion that some women wanted an equal rights amendment. In his view, quote, "The female of the species has the best of both worlds. She can attack laws that unreasonably discriminate against her while preserving those that favor her." Ginsburg reported being depressed when she heard that account of Justice Stewart's talk. She understood that she needed to educate the justices into seeing that all sex classifications, even those that seemed tangibly to benefit females, always came with a cost, the perpetuation of harmful stereotypes. From her perspective, the most insidious of those stereotypes was of the male breadwinner and the female homemaker. A lengthy exchange between Ginsburg and some of the justices at oral argument in the case of Califano versus Goldfarb in 1976 reveals how difficult it was to convince elderly male justices that all sex classifications invidiously affected women because of this double-edged nature. The Social Security provision that was at issue in the Geduldig case provided automatically for survivors' benefits to the widows of male employees who were covered by the statute, but required the widowers of deceased female employees to prove actual dependency, meaning that at least 50% of their income, their financial support, had come from their wives. Now, to Ginsburg, such a provision has three flaws. First of all, it seems to discriminate against female wage earners. Second of all, it discriminates against the male recipients of Social Security survivors' benefits. And finally, it perpetuates the invidious sex stereotype that males are breadwinners and women are homemakers. Apparently, some of the justices had difficulty understanding these points. The first question, directed to Ginsburg, came, I suppose, predictably from Justice Stewart, was whether the provision at issue discriminated against males or against females, whether it could not be seen either way, and why Ginsburg had chosen to treat it as anti-female discrimination. If the sexes were switched, and only female beneficiaries were required to establish financial dependency, Stewart wondered, would that make a constitutional difference? Now, Ginsburg's response, predictably, was that, quote, "The line drawn here, like virtually every gender discrimination, is a two-edged sword." Stewart persisted with his questioning. Some recent court decisions had focused on the history of discrimination against women, but he doubted that there could be any analogous history of discrimination against men. Ginsburg responded that, quote, "Most anti-female discrimination was dressed up as discrimination favoring the women." Stewart at this point replied impatiently, I know that, but the courts, through the help of advocates such as you, have been able to see through that, haven't they?" That comment elicited laughter from the audience. Ginsburg gamely reiterated that sex classifications almost inevitably harmed women. Persisting, Stewart asked her to imagine an instance of discrimination against males. Would her constitutional argument be equally strong? Ginsburg replied, of course, that her argument would be unchanged because I don't know of any purely anti-male discrimination. In the end, the women are the ones who end up hurting. At this point, recently appointed Justice John Paul Stevens took up the same line of questioning. Should discrimination against males be subjected to the same standard as discrimination against females, or to a different one? Ginsburg repeated her previous answer. Almost every discrimination that operates against males operates against females as well. Bewildered and apparently growing annoyed, Stevens responded, "Is that a yes or a no answer? I just don't understand you. Are you trying to avoid the question?" Ginsburg insisted she was trying to clarify, not to evade. She was aware of no sex classifications that did not operate as a double-edged sword. Now, the exchange went on to similar effect for a while longer. Then came from the bench this objection, quote, "But your answer always depends on their finding some discrimination against females. You seem to put that in every answer to this question." Ginsburg, who must have been growing at least a little bit exasperated at this point, reiterated, quote, "I have not yet come across a statute that doesn't have that effect." Stevens persisted, "But if there were one, then you would say it would be treated under a different standard, wouldn't you?" Not wishing to alienate a potential ally on the bench, but not wanting to make a concession that would harm her case, Ginsburg then relented. If there were a statute like that, she would reserve judgment on what the standard of review would be, but she repeated she had yet to come across such a statute. Now, Justice Stevens and Justice Stewart were very smart men. Their inability to comprehend what I think most of us today would regard as a fairly straightforward point, I think demonstrates, it speaks volumes to the challenges that social reform lawyers face in confronting a deeply rooted ideology that makes a system of discrimination and oppression seem just and almost inevitable. All right, to sum up then, black lawyers challenging racial inequality, female lawyers challenging sex inequality, confronted many challenges. Black lawyers, especially in the South, face the threat and reality of physical violence, the risk of legal sanctions for ethical transgressions, and racially prejudiced judges and juries. Female lawyers, feminist lawyers like Ruth Bader Ginsburg, had a hard time even securing a legal education, a hard time breaking into the profession, and a hard time convincing mostly elderly male justices of the seriousness with which their claims deserve to be taken. But the world has changed a great deal in the last 50 years. One always wants to end on a positive note. A black man has just completed a very successful 8 years as president. To many of us seems more successful every day. A woman just narrowly missed through a fairly bizarre and fortuitous series of events becoming president of the United States. 2 of the last 5 secretaries of state were African American. 3 of the last 6 secretaries of state have been women. There are 3 women today on the United States Supreme Court. There were none throughout the country's history until 1981. There's also a Latina, an African American, 5 Catholics, and 3 Jews in a country that had an unofficial Protestant establishment as late as 1960. Same-sex marriage, which was almost literally laughed out of court as a legal claim in 1970, is now the law of the land, and opposition to it declines significantly every year. To finish, I don't know if I agree with Martin Luther King Jr. that the arc of the universe bends toward justice, but I do know that it's possible to push the universe in that direction, and that lawyers such as Thurgood Marshall and Ruth Bader Ginsburg, heroic social reform movement lawyers, have helped to do so, and there's always a lot more of that sort of work to be done. I hope you're as inspired by these individuals as I am. Their lives, I think, confirm the old adage by Oliver Wendell Holmes that it's possible for a man or a woman, he might have added, to live greatly in the law. There's at least as much of this sort of heroic lawyering that still needs to be done today as needed to be done in the past. Today's progressives, who I think appreciate the unprecedented threat that Trump poses to American democracy and are committed to doing what they can to resist that threat, they face a comparative picnic, a walk in the park relative to some of the difficulties that these past civil rights lawyers confronted. So I don't think you should be dispirited or discouraged. I think you should be hopeful. I think you should be angry. I think you should be committed, and I hope that you'll get to work. Your country needs you. The cause of social justice needs you as much as it ever has before. Thank you very much. It's been an honor to have the privilege of teaching many of you. Good luck going forward.